Swayam Prabha. Digital India. Educated India.
Now we come to the third type of compulsory license, which is mentioned in section 92. 92 deals with a special compulsory license, and this is a special provision, and when something is mentioned as a special provision, we understand that as an exception. It cannot be the rule. So 84 is the rule, and 91 could again be a general application wherever somebody requires a license to a related invention, that could again be considered as a of general application. 92 comes into play only under special circumstances. 92 deals with special provision for compulsory licenses on notification by the central government. The prerequisite for 92 to kick off is the fact that the central government should make a notification, whereas 84 we saw that 84 is market initiated. A person who has the capacity to manufacture can approach the controller with a license. So it is market driven. 91 is also market driven in the sense that a competitor can approach the controller seeking a compulsory license as and when there is a need. Again, that is market driven. 92 is not market driven. 92, the central government has to first pass a notification. So the power to initiate a 92 license should first begin with the central government issuing a notification, and only then 92 can be even implemented. So you cannot make an application under 92 directly to the government, which was done recently in a case, and rightly the government rejected it, because the prerequisite for a 92 license is that the government has to issue a notification. You can ask the government or request the government to issue a notification citing the need, but you cannot make an application till such notification is issued. So if a question is asked, can a compulsory license under section 92 be filed by a party if the party feels that the conditions under 84, all the three conditions are satisfied, can a party seek a 92 license? The answer is no. A 92 license can only be sought for after the government has issued a notification. So unless the government issues a notification, you cannot approach the controller with a 92 license. So that's the key distinction between an 84 license and a 92 license. An 84 license does not require a government notification. 92 license, you cannot do anything unless there is a government notification. Now let's look at the details. 92.1. If the central government is satisfied in respect of any patent in force in circumstances of national emergency, that's the first condition, or in circumstances of extreme emergency. Now, what is a national emergency and extreme urgency? We will look at that soon. Or in case of public non-commercial use, that it is necessary that compulsory licenses should be granted at any time after the sealing. Again, the word sealing should be read as after the grant thereof. To work the invention, it may make a declaration to that effect by notification in the official gazette, and thereupon the following provision shall have effect, that is to say. So the first step for 92 to be activated, or for seeking a compulsory license under 92, the first step would be to look at whether the government has issued a notification in the official gazette. So the condition for a 92 is that there has to be a declaration by notification in the official gazette. The official gazette is the official record by which government makes public announcements. So something is published in the official gazette, it is a record that something has been published by the government. So a notification in the official gazette is a requirement. Once the notification is made, now what are the conditions for that to trigger that notification. One, in respect of a patent that is in force, there is a circumstance either of national emergency. Two, there is a circumstance of extreme urgency, or there is a case of public non-commercial use. We will explain these things soon, but in these circumstances, a compulsory license can be granted after the grant of the patent anytime. There is no 3-year limit if the government makes a notification to that effect, saying that there can be a compulsory license in lieu of national emergency, extreme urgency, or public non-commercial use. Whatever the condition, the government can make a notification. Only then the procedure under 92 can actually be initiated. Now let us look at the procedure after the notification. So let us assume that the notification is there. Now the controller shall, one says that the controller shall, on application made at any time after the notification by any person interested, grant the applicant a license under the patent on such terms as he thinks fit. So once the notification is made, any person interested shall make an application and the controller can grant. 2. In settling the terms and conditions of the license granted under this section, the controller shall endeavour to secure that the articles manufactured under the patent shall be available to the public at the lowest prices consistent with the patentee deriving a reasonable advantage for their patent rights. So, one, the controller shall grant. Once the notification is in place, somebody files, an interested person files an application for compulsory license, the controller shall grant the compulsory license. 2. In settling the terms, he shall ensure that that article, that patented article is available at the lowest price, and also ensure that the patentee gets a royalty, because in every compulsory license what the controller is in effect allowing is the use, the manufacture and sale of the patented product by a third party other than the patentee. This is the effect of a compulsory license. When a compulsory license is granted on the terms that a controller decides, the controller is in effect allowing a third party to manufacture and sell the patented invention at a price which will obviously be lesser than the price at which the patentee is selling. Now, whatever price the controller fixes, the controller will also ensure that a royalty is paid back to the patentee. This is a part of any license. A license would allow you to use another person's patent in lieu of a royalty. So, royalty is the consideration for using the license. So, similarly, this is the case in a voluntary or a normal license. Even in a compulsory license, the dynamics, that is why we call it a license. You are allowed to use the technology, though not by the patentee, by an order of the controller. So, that is why we call it compulsory. You are allowed to use the technology, and because you are using the technology, you have to pay back a royalty to the patentee. So, the controller shall ensure that the lowest price is fixed. At the same time, by fixing the lowest price, a reasonable royalty, an advantage, here the word advantage is used, is also given to the patentee. Provisions of section 83 are the terms on which, general terms for the grant of compulsory license. 87, 88, 89, 90 shall apply with regard to this section as it applies to a section under 84. So, the terms, how the controller fixes the terms and all those things, whether it can be non-assignable, whether it can be exclusive, non-exclusive, all those terms will govern even the grant of 92 license. But the grounds under 84 will not apply. Rather, the grounds are different here. The only ground is that there should be a notification by the official gazette, and that notification should be in the light of a national emergency, an extreme urgency, or public non-commercial use. Subsection 3 states that notwithstanding anything contained in subsection 2, where the controller is satisfied on consideration of the application referred to in clause 1 of subsection 1 that it is necessary in a circumstance of national emergency or a circumstance of extreme urgency or a case of public non-commercial use, the three cases which may arise or is required as the case may be, including public health crisis relating to AIDS, acquired immunodeficiency syndrome, human immunodeficiency virus, tuberculosis, malaria or other epidemics, he shall not apply any procedure specified in 87, section 87 in relation to that application for the grant of a license under this section, provided the controller shall, as soon as may be practicable, inform the patentee of the patent relating to the application for such non-application of 87. Now, 87 is the procedure to be followed in 85 and 84. Now, we have seen that the controller makes a prima facie assessment that there is a case, and then he asks the party to serve copies on the patentee. The patentee can oppose, notice of opposition is given, the controller hears both the sides and then passes an order. Now, this is the procedure under 87. Now, in certain cases, the controller can ensure, and now what are those cases? It includes a public health crisis relating to AIDS, human immunodeficiency virus, tuberculosis, malaria and other epidemics. He can ensure that the procedure of 87 is not followed, which means he need not ask the applicant to serve copies on the patentee. He need not entertain an opposition from the patentee, a notice of opposition, and he need not hear the parties. Now, but what is envisaged here in the proviso is that as soon as may be practicable, inform the patentee on the non-application of section 87. But the controller has to inform the patentee that there is an application that has come, and patentee will definitely be informed, because once the notification is in place, the patentee will be put to notice that anybody can now seek a license, and it's going to be a process, and whether it involves AIDS, human immunodeficiency virus, tuberculosis, malaria or other epidemics, the patentee will certainly know what is the surrounding circumstances under which the notification was issued. So, the moment the controller informs the patentee may intervene or may seek legal recourse to protect its rights. So, all that is required under section 92 is to inform the patentee. That's it. There is no need to entertain opposition, there is no need to hear them, and there is no need to pass orders based on the hearing. So, this is a special category of license, and we saw that in certain circumstances even the procedure laid out in 87, 88, 89, 90 need not be followed. More specifically, the procedure in 87, because 88, 89, 90 are more on terms and the powers of the controller. 87 requires hearing the patentee giving a patentee an opportunity to file an opposition. So, there is no need to follow that in the case of a license under 92. So, 92 is the third type of license.